Hi, everybody, and welcome back to Crime in the Courtroom. John Collins here with you, and I am excited once again to introduce our featured season sponsor, ProMega, host of the International Symposium on Human Identification, the largest conference in existence that is dedicated to the practice, challenges, and opportunities of forensic DNA testing. For over 45 years, ProMega has been helping scientists find the answers. Going beyond a focus on products, my friends at ProMega recognize your challenges and collaborate to develop next generation solutions to bringing a network of diverse ideas to drive better results, not only for our criminal justice system, but for our daily lives. ProMega, turning questions into discoveries. Visit ProMega at promega.com. As always, we are here to do some deep digging into our criminal justice system, our efforts to respond effectively to crime, and the ethical obligation that we have to make sure that the adjudication of these crimes is as fair and effective as it possibly can be. Sometimes, unfortunately, the judicial process becomes reinvigorated, let's say, by the discovery that a previously convicted defendant, one who has likely been serving time in prison, may have been erroneously convicted, which is considered to be the ultimate catastrophic failure for anyone who makes a living working in our criminal justice system. When I first got into forensic science in 1993, post-conviction litigation, as it was called, or as it is called now, was really in its very early infancy. You never heard anything about it on a grand scale. The attitude of most of our criminal justice system, agencies, professionals, and so forth, was that once you're convicted, it's game over. Unless there's a viable appeal that changes the outcome of the original trial, your due process is over. But now everything has changed. We have advocates who specialize in representing convicted defendants who have a strong case for innocence. And today I had the opportunity to speak with one of those advocates, someone who is very well known in the field and was kind enough to join me for a conversation about her work, her career, and what she sees as being opportunities and challenges facing the future of our criminal justice system. Dr. Sarah Chu is the Director of Policy and Reform for the Perlmutter Center for Legal Justice, which is based at the Cordoza School of Law in New York. Not only does Sarah have a long history of work within the Innocence Project and within a variety of important circles in the post-conviction realm, she also has an extensive scientific background, which explains the deep interest she has in forensic evidence, which we had a chance to talk about during our conversation just earlier today. So, without further ado, I hope you enjoy my conversation with Dr. Sarah Chu. Sarah, tell us a little bit about the Perlmutter Center. Obviously, I know a good bit about your background with the Innocence Project and the work you did on the public policy side for quite a long time. And then you moved into this new position. Tell us a little bit about Perlmutter and what your role is there and the things that you spend your time on right now.
Yeah, so the Perlmutter Center for Legal Justice at Cardozo Law. It's an exciting new center that started at Cardozo Law School. Many of you know Cardozo from its role in the starting up the Innocence Project in the past. And the school has a long history of social justice and robust clinical programs. And so when Josh Dubin, our executive director, was contemplating a place for the center, that Cardozo was a natural place to go. And we are funded by the generosity of Laura and Isaac Perlmutter's foundation. And we're a little over 2 years old now. And our center has four primary functions. So on the legal side,
Hmm.
we represent people who have claims of innocence, who are pursuing resentencing or clemency. And it's often people who were convicted as children and
Oh,
to
wow.
overly long sentences. Um, and we educate students here. And so we have a clinic where we teach students about forensic science, and they participate in supporting our casework. We also have a training component. And so the clinic is called the Freedom Clinic. And so it's been really exciting and to see the kind of work that the students are able to do and how they're able to contribute to people's freedom. We train legal practitioners, and finally, my portion of the work is the reform work. And so, as the Director of Policy and Reform, we do work in two primary areas. And one is forensics related. So, that's the work that I've been doing for, I think, over 16 years now.
I was going to say,
And
it's been a while.
yeah, yeah. And so it's focused on ensuring that there's systems in place to promote forensic science oversight, accountability, transparency, and what I think is particularly important as we're coming into this age of technology, this rapid advancement of technology, how to ensure the just and ethical implementation of technology and how it might be modifying how we do forensic science. And the second component of our policy work is improving systems to deliver justice and freedom to the wrongfully convicted. So in New York State right now, we're working to preserve the progress that we've made in our discovery laws and to open pathways for people be able to pursue pursue justice in post conviction when they've been wrongfully convicted.
Sarah, do you have a sense, and I'm aware of probably the unfairness of this question because it's so difficult to answer. The Do we have an idea of what the prevalence actually is of wrongful convictions in the United States? Is there any way statistically with using, I guess what we would call robust research methods to get a sense of how often it does occur?
The consensus right now in the community is based on a number of studies that have been done, primarily Sam Gross's death penalty work and Loeffler and colleagues at from University of Pennsylvania have done a study where they surveyed people who in the Pennsylvania state prisons and did a estimation from there, but the estimate is 4 to 6%.
Okay. That's a lot when you're talking about, I don't know how many hundreds of thousands of criminal adjudications take place in the United States each year. Even if the criminal justice system had an accuracy rate of 99%, right? You would you would still have a good number, even at that success rate. That 1% is still a lot of people. Right. And all you can do is estimate. So most of your time then is spent when you talk about reform is really trying to prevent the things that contribute to these erroneous convictions on the policy side. So my guess is you spend a lot of time in Washington, D.C. these days, or is it mostly in New York? Where do your travels typically take you?
So these days, I'd say that a lot of our wrongful convictions focused work is based in New York. and
Okay.
that the forensic science work that I do is I have the opportunity to work with people from across the country, and um, and it's in part because forensic science, just like law enforcement, is uh, locally and or overseen at the state and local level. And so the changes that I think are tangible are more likely to happen at the state level. And
Yeah.
so among the kind of issues that we are pursuing are or the creation or supporting the creation of forensic science boards. And and a passion of mine is how to help labs respond when things go wrong.
Hmm.
And I think that there are ways to do it where we can improve, um, where we can de-escalate the the finger pointing and the blaming and encourage cultures of disclosure where we can look at the the root causes of what happened and address those root causes in an open and transparent way. Uh, Address those root causes and respond to what the problem was, and
Sure.
um, and repair the harm in open and transparent ways.
Do you think that the cultural influences that law enforcement has over a lot of forensic labs affects in any way how, let's say, a laboratory that it falls under the control or command of a law enforcement agency, that can affect the way that it sees some of these problems?
Absolutely. And I a core part of how I viewed my work and my job over the last 16 years is that I had the opportunity and continue to have the opportunity to attend conferences and develop relationships with practitioners and hear directly from forensic scientists about the challenges that they have in their workplace, organizational challenges, and system level challenges. And while, so something surprising that I heard, and this is from forensic scientists across the country, is that yes, talking about mistakes and talking about the human aspect of forensic science that can be fallible um, is hard because of potential defense challenges. However, the impact of that kind of openness, transparency, that disclosure, that it's felt really through how law enforcement responds. So, forensic scientists I've spoken to have mentioned the Brady lists, that if you um, are involved with a quality incident, even if it's not your fault, even if there was some other systemic issue, even if it was an honest human error, that just simply being associated with a quality incident, nonconformance, or corrective action is cause for law enforcement authorities to consider not using you in trial. And if they don't want to use you in trial, then it impacts your ability to remain employed in your laboratory. And so I think that there is a reach that law enforcement has that it doesn't realize into the day to day mental health, professional practices of forensic scientists that we really need to talk about because the overwhelming number of forensic scientists that I've spoken to, they want to be able to raise when problems occur and to fix them right away. But if there are other perverse incentives in the system, that are preventing that from happening because people are fearing um, their ability to continue in this profession that they love, that they're committed to, or to remain employed to support their families, that it can really change how a laboratory practices.
Sarah, I have coaching sessions. Forensic science professionals are about 60% of my coaching practice, and I've sat in coaching sessions with forensic scientists that really have led me to believe over the years that today's younger, newer forensic scientists in their first year of employment are experiencing a lot more anxiety
Yeah.
than me and my contemporaries did. That really bothers me, not only as a coach, but it bothers me as a somebody that, like you, cares a lot about forensic science. And these cultural influences are not to be taken lightly, as you said. And I, it's a the subject that you're touching on is a passion for me as well, and I appreciate you bringing it up because the impact of law enforcement culture on the practice of forensic science, I think, is one of the more fascinating and important subjects that exist in criminal justice right now. I'm curious, how has your opinions of forensic science evolved since you first kind of got into this? And if you wouldn't mind, as long as I ask you that question, can you kind of tell the audience a little bit about how did you get into even having any interest in forensic science in this particular context?
Okay. So, how did I get into it and how my views have evolved?
Yeah,
How did I get into it? I was a teacher in New York City teaching middle school science. Um, and I got to a point where I couldn't repay my student loans unless I took another job. And so I went into the private sector. And while I was there, I took a public speaking course because public speaking, I think, is like one of the top fears that people have. And it was something that I've had to train on for years. And so in one of my classes, I met uh, a, a policy analyst named Gabriel Oberfield from
I
the
remember
Innocence
Gabe.
Project. Yes.
Oh, absolutely. Yeah.
Yeah. And so he told me about what he did. I think we were partnered for an activity, and I thought, wow, that's so cool. I would love to do something like that, but I'm not a lawyer. And so I just put it out of my mind as, realm of possibility. And then later on, um, during a period when I was job searching, there was a role that opened that where they were seeking a scientist who had policy experience. And I'd been for a long time active in my local community. I that counted. and, um, and I had this science background and an interest in policy work. And I was, I think, the 40th employee at the Innocence Project.
Wow.
And so that I was hired on very early in the organization's growth. And so I was hired right before the NAS report came out.
Oh,
And
okay. 2009.
right. And so it was the fall of 2008. And my job was to read everything I could about forensic science. Then, upon the publication of the NAS report, to work on advocacy for our priority recommendations. And and so a lot of my work in the first decade, I think, of my time at the Innocence Project was focused at the federal level. And
Okay.
then over time, we branched out into doing more work at the state level as well.
Okay. And in your view, boy, you had kind of a baptism by fire if you came in kind of 2008, right? 2009, at the time of the NAS report. Probably a good time to come in and start taking interest in this stuff because there were conversations that were starting that we just hadn't had before because we didn't have to, right? But what you also have probably even since 2009, but certainly in the 30 years that I have been working in and around forensic science is the demand for the services within the criminal justice system at the investigative level, and then obviously at the judicial level once it goes to court. And I think you might agree with this that DNA had a lot to do with it.
Right. DNA definitely catapulted forensic science into the view, I think, and the consciousness of the entire country. And and it played a really important role as kind of an orthogonal technology. And so if you could take a piece of evidence and understand it in different ways. And so let's say a fingerprint in blood, and then if you process a DNA test, the blood, that if you got different answers using, you know, evidence in a case, that it it was informative and in a way that we hadn't had before. And I think it created this conversation and a national interest in forensic science. And we were seeing the benefits of a newly implemented technology. And something I'm very interested in, and this is kind of taking us a little bit off topic, but the incredible conversations and the degree of responsibility that policymakers felt when DNA was being implemented. And like most technologies, it started off with, you know, trailblazers picking it up, implementing it in cases. And then over time, it drew the attention of people who were interested in ethics, in bioethics, in privacy, and lots of conversations were being had across the nation about, okay, if we're using DNA, what does it mean to be using personal data like this? And what protections can we create for the collection of that data, how we store it, how we use it, and who has access to it? And luckily, all of that happened in order to create CODIS. And those conversations, to me, fell off as DNA became cheaper, more ubiquitous, and more commonplace. And so, how we think about DNA today, the ways that we use it, I don't feel like we go through the same conversations that were had back in the day. And that we need to have a return to that interest, that consideration of what it means to use people's data, especially as we're entering a period of rapid growth in technology that is used in the criminal legal system for and is run off of data. You know, whether it's biometric or social or or geographic data, that all of that is information that relates to people that I don't think, have prepared enough for to ensure that we're appropriately using it.
Do you think that DNA as a forensic technique has become a little bit commoditized? Like we've become a little bit too familiar with it. It's more routine now. And whenever something becomes routine, we sort of perceive that its value is lower because when something is new and novel, we think, "Oh my gosh, this is great," and so we take it really seriously. But we've been doing it so long. Do you think do you think that that is part of what's fueling these changing attitudes?
I think so, that commoditization um, and the popularization of DNA
Sure.
as a commodity. So, you can, with all of the ancestry type of testing, um, where people think nothing of swabbing and sending their information to a private company to hold their data, their genomic data. Josh Dubin, the executive director of the Perlmutter Center, he calls it the sacredness of our DNA information, that as a society that we've lost that, and we don't have to lose it. It's something that we can reclaim. There are other societies and cultures where DNA information and privacy is still considered a very important value. And and I think that we need to return to that, because if we don't perceive DNA with that level, if we don't see DNA as sacred, then all of our other information and all of our other data would fall behind it, in the hierarchy. And so if we devalue what it means to share DNA, then it also devalues what it means to have all of our other data either shared or taken.
So I'll tell you what, let's expand the conversation a little bit, or get into some specifics with regards to what we see in the courtroom, in our criminal justice system when it comes to forensic science from a policy standpoint. And when you talk about the potential for reform efforts, from your perspective, where do you see within the forensic science occupation, let's say, where do you see the most opportunity or the most need for change or reform?
I would like to see a revitalization of how we respond to mistakes and errors when they happen. Because I feel like if there is, if there are healthy ways for forensic scientists to be able to do that, and if there are systems created by laboratories to help facilitate healthy ways to respond to errors and mistakes, that that would start the kind of cultural shifting that we need in order to bring forensic science into this, to really be able to do continuous improvement. So we talk so much about continuous improvement in quality management, but the criminal justice framework and the way that the courts work, they're really not conducive to continuous improvement.
I think, if you don't mind me just interrupting real quick, because I think that's an absolutely key point that you're bringing up, that a lot of people get confused by. And let me just take 30 seconds and explain this thought and then tell me what you think of it. Is that a lot of times when people think of forensic science, particularly the circles that I used to run in and still run in, people that work in forensic science laboratories, right, that are doing the testing, that when we think of forensic evidence, we think of the laboratory. We think of what's happening in the lab. And there's a lot of lab directors out there that would say, Dr. Chu, we have accreditation, we have corrective action procedures. However, what it took me a long time to realize is that when, particularly in the post-conviction realm, that when you talk about forensic science or forensic evidence, it has a different meaning, in that forensic science is what is coming into the courtroom. It's the testimony that the jury or the trier of fact is hearing. And my own experience supports what you're saying, in that the courts don't really know how to handle it when something goes south.
I agree. I agree.
Okay.
The courts are really not well adapted to handle science. And that's been a major problem because science is continuously changing,
Right.
and sometimes it's through little steps, and sometimes it's through revolutionary leaps. And the court remains a system that is focused on the past, where where participants are afraid to take steps that deviate too much from what has already been decided or printed um, or opined on. And so, with regard to science, there really needs to be kind of a national conversation about how courts um, can be responsive to science in a way that advances and improves science and um, recognizes how technology moves forward. So, an
Yeah.
example I'll give you is that um, in terms from the post-conviction framework, that one of the ways that you can get attention for your case through the courts is through newly discovered evidence. And this really came into focus when innocence advocates were advocating for um, post-conviction DNA access. And in some states, there are very, very strict limitations to how when you can introduce newly discovered evidence, like within years of a conviction. And as we know, with science, sometimes revolutions take 20 years, sometimes they take 2 years, and all of that is um, it, it, we can't we can't always predict when scientific breakthroughs will happen or when we have a different understanding of information based on newly acquired knowledge. And so in the post-conviction setting, it can be really frustrating because if there are time limitations to when you can um, introduce new evidence, or if there are different interpretations of what newly discovered means, then it precludes people from being able to use good evidence that can prove their innocence.
It's interesting. We're having this conversation on the heels of, I mean, what I would describe as this is the, I mean, this what happened recently out in Colorado with, is it Woods? I think was the scientist's last name, a DNA analyst, and the what appears to be, from what we can tell, sustained gross misconduct, and that probably rivals the Annie Dukin case. And I always hoped that I would never see another situation that would ever rival the Annie Dukin case. But boy, it's been tough, and there's some good folks there out in Colorado, and it's an accredited lab system, and that's one of the Annie Dukin's lab was not accredited, and that's I think for those of us that you know that we do call ourselves forensic science professionals, this one really stings. What was your thought when you first learned of that, or maybe some of your other thoughts on things that have happened here recently that have made the news in forensic labs?
I want to be careful because I've heard from many forensic scientists that you don't always get the full story in the news and in what's
True.
being reported.
Yeah.
And so if I'm conditioning my response on what I've heard reported in the internal affairs report that was published, um, there seem to have been some data preservation issues that were overlooked that could have minimized the scale of the problem.
Mm.
So, one example was not retaining the output from the instrumentation. And so I think that now that we know that, that should be on every single laboratory's, you know, a memo for every lab to be thinking about what their data health practices are and how data is preserved and documented appropriately. And there were, that internal affairs report demonstrated organizational weaknesses and accountability.
Mm.
There were many people who identified the problem and and reported the problem, but um, but they weren't heard.
Okay.
And um, and then I would also note that what I found to be of interest was that the people who identified the problem often came from other laboratories. They were people who had worked in other systems. And when they were introduced to the system of practice that they were in, they identified areas of improvement, or that was what led them to understand that this examiner's behavior was concerning.
Mm.
And so I thought that it really shows how important it is to for scientists to have opportunities to see other systems and to be introduced to the broader world of practice that you get at conferences. And that's one of the opportunities um, that most forensic scientists don't have ready access to, is all
Mm.
the scientific resources that you need to do your job, which includes attending conferences, having discussions with people from across the country, and hearing from a diverse range of people who do the work that you do, to learn from their practices and taking things back to your lab.
Yeah.
And um, and so those were some of the things that I identified based on the internal affairs report. But moreover, we're getting back into the question of incentives. Like, backlogs are used to measure laboratories in a way that I think we should be recognizing the what it means when we set that as a lab's primary measure of productivity. And if we're not celebrating or measuring really good quality practices or scientific behavior, um, or if a scientist is able to resist um, other contaminating influences, that all those things that we associate with good science that we want in the forensic science system aren't what we reward. And what um and so that focus on the backlog, I think, um is something that we should really be talking about, because of I, you mentioned, I was so sad to hear you mention that young forensic scientists are feeling more stressed than ever. That, to what degree do backlogs and the pressure to produce, and as figure into it, and as we know more about forensic science, and as we know more about what standards and guidelines and practices we should be and guardrails we should be putting into the practice to improve the scientific output, that that has a that pushes against um, th- reducing backlogs. Because if you're going to require more steps, if you're going to require more documentation, that take all of that takes more time and resources. And if you're existing in a system that is famously under-resourced, and where productivity in terms of number of cases is the measure by which you're being assessed, that we can't help but have more cases or more instances that are reminiscent of what happened in Massachusetts.
Yeah. I To add to what you were saying, one of the things that has changed, and I think this adds to the stress as well. One of the workshops, one of the online workshops that I do is called the Professional Orientation School for New Forensic Scientists, and everybody that comes into that program fills out a little questionnaire. And one of the questions that I ask every single student that comes through us, there's hundreds of people that have come through it now, is who do you see as being the customer of forensic science? And what I found really fascinating about this, Sarah, is the number of people that select victims as being the customer of forensic science. When I got into the field in 1993 or two, whatever it was, dating myself, you kind of knew you were going into law enforcement. It was a criminal justice position, right? You're part of the investigative process. I think that's all changed now. A lot of these young people that are coming into forensic science see themselves as being expediters of justice in the interest of serving victims of crime. Now,
Mm.
there's a lot about that that's good, but I think it puts a different kind of pressure on people. One of the options that the students can check is society. And another
Mhm.
option I think is just the criminal justice system at large. But I'm stunned by the number of students that select victims as being who they perceive as being the customer of forensic science.
To me, that makes sense in the sense that forensic science is really mission-driven work.
Yes.
That if earlier you asked what I learned and how my views changed. Something that I learned in the course of my work is how much people give when they go into forensic science. And, you know, I'm hearing anecdotally about more and more forensic science students going into clinical testing or pharma because the compensation is better.
Yeah.
And so for the people who are going into forensic science, they really do care about the impact of their work and the fact that they're serving the system. But what I worry about um, with with young folks who are focusing on who are doing it for the victims is that it ties their work to an outcome and that their sense of success will be tied to an outcome and that that connection could potentially create cognitive bias or it could create mental health impacts if something didn't go right, or if the person who was being prosecuted was acquitted, could have been because they weren't the right person, but the victim still didn't get justice in that
Yeah.
instance. And that if the victim's outcome is what drives you, then you can internalize that. And so I understand why, and people go into forensic science for many reasons, and I've heard a lot of people having their own experiences with the criminal legal system as an impetus for why they go into forensic science. Um, but I do worry for many reasons if the work is tied to an outcome because I think it has many other consequences down the road.
I agree with you. And some of this is cultural, which we've touched on during our conversation, and that would lead me into a discussion a little bit about oversight, and also in this magical word that we have heard a lot more about since 2009, which is independence. And what are your thoughts with regards to what should be the organizational arrangement of forensic science laboratories specifically, understanding that that is one segment of the forensic science community, forensic science
Mhm.
laboratories. But when it comes to forensic science, what does independence mean to you? And how does oversight tie into that? I'm kind of bundling a couple questions at once there, so forgive me.
When I started work at the Innocence Project, I would have said complete separation outside of law enforcement. And since then, there are forensic science labs that, despite being hosted by a law enforcement agency, that the laboratory directors and the forensic scientists have been able to do their work without outside influences. I think that if we were creating a forensic science laboratory today, and that we wouldn't naturally put it inside a police laboratory, a police department. And and I don't know that police chiefs would want all of that under their roof to have to manage, because if you're doing forensic science right, it is complicated and
Yes.
it is resource intensive and it requires a lot of knowledge that that isn't taught to police as they're growing in their leadership structure. And so I think that we would have different ideas for creating a brand new lab today. And but what can be done is, or I guess we can look for markers of independence, perhaps. Um, and I look at a place like Virginia, Department of Forensic Sciences, where the Department of Forensic Sciences is a sister agency to all of the other components in the criminal legal system.
Hmm.
And they are able to advocate on their own for their budget. And they have, in Virginia, they happen to have frameworks through their forensic science bodies on how they can effectively advocate and support their laboratories. That if you're a lab within a police agency, you often don't have that because it's the overall policing budget that that gets the attention.
Yeah.
And so the ability to obtain resources, the ability to um, define policy on testing. So a policy decision that I am very concerned about is this move to DNA test every gun that that policymakers will make on a whim. And on one hand, I'm glad that they understand the power of DNA, but on the other hand, that policy is calling on forensic scientists to do the hardest kind of DNA testing,
Yes.
where you have um, where you have a piece of evidence that is probably touched by a million people, left in cars or other places that are accessible by multiple people, and there's tons of low-level DNA. And we have limited ways to be able to deconvolute DNA profiles, um, and it really pushes forensic scientists to kind of push the boundaries of their validation in DNA testing. Whereas perhaps uh, dusting for prints and analyzing available prints, um, it won't get you. It may not get you to who was the person who shot the gun, but it may give you a clear idea of who handled it. Um, and so, I mean, that's just an example of how policy decisions are made without um, without incorporating someone in the process who understands forensic science and understands the downstream impacts of making that policy decision.
What if you have a criminal jurisdiction anywhere? but let's say it's somewhere that has a rather high level of crime, high level of case volume, and you have judges, police chiefs, sheriffs who sort of collectively decide amongst themselves, we do not want to have an erroneous conviction here. Like we are just going to commit ourselves to that. What kind of advice would you give to those leaders? In other words, the way that they manage their criminal jurisdiction, their investigations, their courts. What would be sort of your preferred checklist, the top few things that they need to be thinking about to make sure that no innocent person is ever convicted in their jurisdiction?
So the first thing I would recommend is robust open file discovery. And um, and in terms of laboratory practices, robust documentation. And I think it protects everybody. So if you have thorough documentation that is available to everyone, that um, not only do prosecutors and defense attorneys know exactly what the evidence is, but if there is a change in science down the road, it's not because there was some nefarious activity that we're that you can recognize that scientific understanding has changed and you have all the material you need to be able to assess that. Often in post-conviction cases, um, it shouldn't get to post-conviction because by the time it gets to that place, they've been incarcerated. They are in a position of trying to um, get attention again and permission from the courts to be able to try to demonstrate their innocence. And when there's a lack of discovery in at the trial level, that I think that people might not know that there isn't in many states, in most states, there isn't a right to discovery and post conviction. And so a lot of people who are fighting to prove their innocence have to use FOIA or freedom of information type of
Mhm.
laws to try to obtain
As
the
a form of discovery.
right, right. And
Yeah.
so there's lots of limitations and lots of barriers. And so strong discovery practices and strong documentation practices from the beginning protects everyone. Inequitable resources is also a major problem, and that's down the line, right? With
Mm.
defense attorneys not having the same access to, let's say, a new software program than the government would, or making sure that laboratories are well resourced so they can provide that documentation that's so important, and having an openness to someone's innocence. And, one example is a man named Arvell Marshall, who was recently exonerated in Brooklyn. There was surveillance video of the crime that clearly depicted the people who committed the crime. And the prosecutors had that evidence pre-trial, but said they couldn't open the file. And so, in a under robust discovery condition,
Do you mean the video file? They were unable to open the video file? Is that
unable
what you
to
meant?
open the video file.
Okay, yeah.
And so they could have disclosed it and handed it over to Arvell, and he could have tried to find an expert to help him open the file. But
My
that was the
goodness.
rationale for not turning it over. And during trial, he got thrown out of the courtroom because he kept yelling, just watch the video, just watch the video. And Arvell spent 16 years in prison before someone watched the video. And which is just unconscionable when the evidence was already there. And I don't know what the technical situation was with that evidence, but in so many cases, that having a robust layout and itemization and access to evidence would have been would have allowed the innocent person to be able to prove their innocence. Because the problem is when you're innocent, you have no idea how the crime happened. And so it's really difficult to mount a defense. And an innocent defendant almost has to investigate the case in order to prove their innocence.
Yeah.
And so it's like twice as much work as might go into a typical case. And going back to your question, uh, documentation and discovery and equitable resources, I think, would go a long way to improving the system to prevent more mistakes, but also an openness to revisiting when mistakes happen. And in so many cases that we see at the Perlmutter Center, there are people with real claims of innocence who have evidence but just can't get a hearing, or a judge might have a hearing but then determine that the evidence wasn't new, rather than saying this evidence sure existed back then, but now that we're seeing it and it really sheds light on your innocence, it has a different impact on your case. And and a lot of this, I think, comes from the high volume in our system and the desire to quickly get through cases. And so you have this other manifestation of the backlog that really changes the incentives in the system.
You know, I've just always believed that criminal justice is not designed to be an assembly line process. And
Yes.
when you're shuffling people through like cattle, you're setting yourself up for eventual failure that you're going to be held accountable for. So the work that you and your center are doing is just really, really important because there's a lot of that out there. So Sarah, how can our listeners, viewers learn, if they want to do a little bit of research, learn more about you, learn about your center and the work that you're doing there?
Thank you for asking that. So, if you'd like to reach me, if you have feedback about anything from the podcast, of course, reach out to John. But I would love to hear any thoughts and feedback. My email is Sarah, SARAH dot Chu, CHU at YU. Dot edu. So Cardozo Law School is a division of Yeshiva University, which is why it's YU dot
Mm-hmm.
edu. Our center is the Perlmutter Center for Legal Justice, and we're easy to find online if you Google that with Cardozo. And finally, if you or a loved one is in need of help in a post-conviction case, we do take cases from across the country, and specifically cases that have a forensic component in it, that we have the special expertise to litigate those cases. And so our attorneys can be, our intake process can be reached through help.freedomclinic at yu.edu.